Oh, we have one more.
Mhm.
All right, so I think we'll get started, and we will send out a recording both to the people who attended and the people who registered but weren't able to attend. Al, I know you have a bit of an introduction in your presentation, so I won't introduce you at this point. I will just say that when Al and I were talking about this, I feel like the CPTPP has kind of fallen off the radar a little. There's so many other things going on in the world, and obviously election in the UK, that this has become less of a topic for people. But the UK ratified the CPTPP just before the election was called, and once I think we get to half the number of original members ratify this, then it comes into force. And if they don't, then I think by October that comes into force automatically, even if the rest of the members don't. So this is coming up, and I think it's a good time to start thinking about it so that we're prepared for it. And Al, I'll let you jump straight in and explain all the work that you've done trawling through this to work out what it means for Canada and UK employees.
Sure. Thank you very much, Martin and Idalia, to make this happen. And I just want to let you know that I'm looking at this from the immigration lens, and I look at this from the Canadian side. That's how we will discuss this today. So we'll just do a little bit of an introduction about this topic. I'll talk about the current UK-Canada agreement, and then CPTPP and how it could affect the way that employers can hire British citizens in Canada.
Okay.
So just a bit of introduction. My name is Al, or Alirza Parsai. I hold a bachelor's degree in mechanical engineering, a master's degree in psychology, another master's in law from Osgoode Hall. I'm a regulated Canadian immigration consultant. I can also represent clients to IRB. I received my license in 2011, and my business, Parsai Immigration Services, a benefit corporation, is located in downtown Toronto at Sheraton Centre. And I'm also an adjunct professor at Queen's University and an instructor at Ashton College in Vancouver. We've had now clients from 59 countries. So, and I'm the author of 88 Tips on Immigration to Canada, which has been identified by Amazon.ca as a bestseller under the immigration law, and many articles, many CPT sessions, media interviews, etc. So that's enough about me. So the current regime is an agreement between Canada and the United Kingdom, also called CUCTCA or CUCTA. And the actual agreement was discussed when we had the issue of the Brexit, because a Canada-UK agreement was under the agreement with EU, also called CETA. And then after Brexit, Canada and the United Kingdom wanted to have this continuity of all different kinds of agreements between themselves, and that's why they did this. And as far as I know, there will be some amendments that are coming. I'm not sure how much they will affect labor mobility, but at least this is what we are talking about, is the preliminary agreement that happened between Canada and the United Kingdom. And because of that, there are many similarities between what we have with EU comparing to, for example, other countries. An example would be the agreement that we have with Mexico and the United States, formerly known as NAFTA. Nowadays, depending on who you ask, in Canada, we call it CUSMA. In the United States, we call it USMCA. In Mexico, we call it TMEC. So we didn't even agree on the name of the agreement. So I'm not sure about that agreement, but that agreement is really generous in terms of work permits, especially for the main applicants. However, the agreement that we have with EU is not that generous, and there are many limitations. And the Canada-UK agreement is also based on EU. So, of course, the main pillars of CUCTA are continuation of tariff-free access on 98% of goods traded, preserves the high standards of service trade and investment, ensures non-discriminatory access to government contracts, and they have mechanisms for resolving trade disputes remain intact. So this is, as you can see, it's a trade agreement, so it's mostly about trade. However, there are some elements of labor mobility in that agreement. This will cover only the United Kingdom and Canadian citizens. So if somebody is a permanent resident of the of Canada, they are not affected by this agreement. They still need to go through the same process like other foreign nationals, for example, to secure a work permit in the UK. And vice versa, if somebody is a permanent resident of the United Kingdom or a temporary resident of the UK, they are not affected by this. One of the main reasons that we have this agreement is to facilitate the movement of professionals and business persons. Remember that as an UK citizen, if a person wants just to travel to Canada, they can simply apply for an ETA or electronic travel authorization. ETA is not a visa. It's just a security clearance. We want to make sure that somebody who travels to Canada, they have no issues in terms of admissibility. And if they are admissible to Canada, technically they can travel to Canada easily. If a UK citizen wants to travel to Canada by car, for example, from the United States, or by ship, they do not really need to apply for an ETA. ETA is just for air travel. It costs $7. It's very easy to submit the application. About 90% of the applications get approved in a matter of less than 10 minutes. I've had clients that they were stuck at the airport. They called me and we submit the application on the spot, and they managed to hop on the plane and come to Canada. Back in the day when I was representing Toronto Wolfpack in 2018 and 2019, before they went bankrupt and kicked out of RFL, we actually processed more than 400 applications for Wolfpack per year, and majority of those applications were ETA applications, and we could do tens of them in a matter of a single day. But sometimes there are complications and we need to apply for other things like rehabilitation applications, etc. So that remains intact. What has been added is to facilitate the movement of business people. And that's huge because CUCTA expands the definition of business persons in Canada and makes it a lot easier comparing to other nationalities for UK citizens to travel to Canada. On top of that, we have some provisions in place for technicians and professionals to be able to come to Canada and work in Canada temporarily and then eventually leave. We also have some provisions called ICT or intra-company transfer, which allows certain people to be transferred from their own companies or businesses, or the businesses or companies that they work for in the United Kingdom to Canada, or if they are British citizens and they are working for a company that has branches elsewhere, they can be transferred to Canada. There are also some agreements in terms of recognition of professional qualifications, which makes it easier for British citizens to work in Canada. About 20% of the jobs in Canada, they are regulated jobs, and the majority of regulations are provincial based, but at the end of the day, this agreement will to some extent makes it easier for British citizens to acquire those licenses and to be able to work in Canada. And of course, Canada also issues work permits for British citizens based on this agreement. Now, if you want to know more about this agreement, the Global Affairs official website, they actually have multiple pages. They discuss different aspects of this agreement. And on top of that, they also talk about what is going on today and what are the discussions right now around this topic. Now, if somebody wants to work in Canada, they have two different options. So one option is called Temporary Foreign Worker Program, or TFWP, and the other option is called International Mobility Program, or IMP. Temporary Foreign Worker Program involves two different entities in Canada. The first entity is ESDC, or Employment and Social Development Canada, also known as Service Canada. This entity is in charge of looking at the labor market to ensure that if a company is hiring a foreign national, the hiring of that foreign national will not impact Canadian citizens or permanent residents in Canada in a negative way. That's the job of Service Canada. So in other words, Service Canada look at the legitimacy of this job and its impact on the Canadian labor market. If the ESDC department is convinced, then they will issue a letter called LMIA letter, or Labor Market Impact Assessment. If that LMIA is neutral or positive, this means that the employer may offer that job to the foreign national. And then we enter the second stage, which in the second stage, the person needs to apply for a work permit. Now, for many people, they need to apply for a work permit online. This means that they submit their application to another entity called IRCC, which is the decision maker in matters of immigration and visa in Canada. However, we have an agreement between CBSA, Canada Border Services Agency, and IRCC since 2003, that based on the new law, that if a British citizen and pretty much everybody who is exempt from the requirements of visa, if they just travel to Canada, at the port of entry, there are certain CBSA officers. Despite they are border officers, they are also trained to process work permit applications. This means that a UK citizen can receive their work permit at the port of entry. My record in terms of a group of British citizens to apply for work permit at the same time at the port of entry was 17 people in a single day. In a matter of less than 2 hours, all of them received their work permits at the port of entry. So the process for majority of people are super easy. All they need to do is to go through the LMI process. The LMI process right now takes anywhere between 2 to 6 months. So it's a lengthy process. There are some exemptions to that. But at least when we receive the LMIA, the second step, which is just application for work permit, is a matter of having your package, traveling to Canada, presenting that package to the border officer, and receiving your work permit. With the International Mobility Program, we don't even need an LMIA. An International Mobility Program is based on several reasons. One of them, of course, are FTA, or those trade agreements or free trade agreements that we sign with different entities and different, and when I say entity, it could be an agreement with a company, for example, based on the request of the BC government. Canada has signed an agreement with Microsoft in Vancouver. If they hire somebody, then they don't really need to apply for an LMIA. But most of the time, those agreements are between Canada and another country. We have some bilateral agreements, like the agreements with South Korea, with Colombia, with Chile, and other countries. And we have some more complicated and multifaceted agreements, like the one with the European Union, CETA, or with the one with Mexico and the United States, CUSMA, and so on and so forth. And of course, the big one is now CPTPP. Based on those agreements, sometimes it's because of Canadian interest, sometimes it's because of humanitarian reasons. that Canada decides to exempt a person from going through the process of LMIA, and they just allow them to receive a work permit. Interestingly enough, about 75% of all the work permits that are issued in Canada are IMP based. It means that people will not actually go through the LMIA process. The LMIA process is expensive, it's time consuming, and as I mentioned, it could take up to 6 months. Most of the time it is processed in 2 to 4 months. To receive that document, if you receive that document, because the success rate for LMIs is roughly around 75% to 80%. So there is a chance of refusal. And even if the application gets approved, it takes a very long time. The processing fees of $1,000, et cetera, et cetera. So because of that, if you have the opportunity for an IMP application, we go for IMP application. And the whole subject of agreement with the United Kingdom is to get rid of LMIA. Now, if you look at this slide, we realize that there are different options available to UK citizens. For example, we have the UK independent professionals, F60, which I forgot to include in my slides, but again, it's similar to UK contractual service suppliers and UK engineering technologies and scientific technologies. So there are 3 special codes for professionals. Today, I focus mostly on F66 and F67, but F60 is also very similar to contractual service providers. We also have some options for intra-company transferee for people that they are executive and senior managers of a company that is in the United Kingdom, and they, or maybe other countries, they have a branch, a subsidiary, or an affiliate here in Canada. And based on that, we can transfer some of the employees like executive senior managers, management trainees, and specialized knowledge people to come to Canada and work in Canada. They usually receive a 1-year work permit, and they usually can extend that work permit up to 7 years. In specialized knowledge cases, up to 5 years. We have a special option for spouses of ICT applicants that they could also receive work permits. Now, when I say spouses, I'm talking about spouses or common law partners. We also have an option for investors, those people who are investing significantly in Canada, then they could secure a work permit and come to Canada and work. Now, in terms of F66, which is very similar to F60, the subject must be a citizen of the United Kingdom. They must be engaged in a temporary supply of a service for up to 12 months. And they also must have a contract based on the Annex 10E. And as I mentioned, this agreement mimics CETA, and Annex 10E is actually an annex that is part of the CETA agreement. So they must meet that, and then they must have a university degree or equivalent qualification. So they must show that they are qualified. Generally speaking, depending on the case, they need anywhere between 3 to 6 years of work experience in what they are doing. And then if their job is regulated, then they must ensure, I mean, regulated in Canada, they must ensure that they have proper licenses in Canada. Now, as I mentioned, there are some opportunities for certain jobs to receive a license easily in Canada. I've had clients in the past that they received a temporary license to be able to do their job in Canada, and then they later left. But with the F67, which is engineering technologies and scientific technologies, the circumstances around that are to a great extent similar. So they must be a citizen of the United Kingdom. They must provide proof of citizenship. They must have a contract. And then there are certain documentation that they need to provide. And they could receive, again, a work permit. So the duration of the work permit is usually a maximum of 12 months. And there is also a ban. In other words, if you receive the 12 months work permit, then you need to wait at least 12 months and then apply for the second work permit, which makes it very inconvenient. So if somebody comes to Canada and they receive a 1-year work permit, they can work in Canada, but they must leave. Or if they find another way to secure a work permit, for example, through LMI-based applications, then they can secure another work permit. But if they want to use the same codes, F60, F66, or F67, they must actually go ahead and wait for at least 1 year. And then after 1 year, they can apply for a second work permit, which is not very convenient. And I think, again, it's part of the discussions that we had with EU. EU didn't want to be very generous towards Canadians, so we kind of reciprocate. And in extensions possibles, again, as I mentioned, after 24 months. Now, what about CPTPP? So this stands for the Comprehensive and Progressive Agreement for Trans-Pacific Partnership. I can assure you I have tried probably 10 times and I never managed to memorize this. So don't worry, just let's stick with CPTPP. It's a trade agreement that is right now between 11 countries. The United Kingdom will be the 12th country. Obviously, Canada is one of them. It aims to enhance trade and investment, promote innovation, productivity, and competitiveness, and also reduces tariffs and fosters economic integration in the Asia-Pacific region. Now, the countries that are right now members are Australia, Brunei, Canada, Chile, Japan, Malaysia, Mexico, New Zealand, Peru, Singapore, and Vietnam. Some of these countries, they already have mutual agreements with Canada. For example, Chile has an agreement with Canada, Mexico has an agreement with Canada, Peru has an agreement in Canada. So when we have a citizen of those countries, we not only can apply for their work permits under CPTPP, but sometimes we apply for a work permit based on the mutual agreements that we have with them. So always as a consultant, I look into which option provides better opportunities for my clients. Now, interestingly enough, some of these countries under CPTPP, they do not just limit the agreement to their citizens, but rather to their permanent residents as well. One example would be Australia. So if a person is a permanent resident of Australia, could still secure a work permit in Canada based on the CPTPP agreement. So we don't know what's going to happen with the United Kingdom because right now, as Martin mentioned, we are waiting for finalizing the agreement between the United Kingdom and the rest of the members, or the internal agreement, let's put it that way. But at the end of the day, if it happens, which apparently it will happen anyways, then the next step for Canada is to decide to what extent they want to go ahead. So we have some sort of general options available to all members, but we have specific agreements with each of these countries in terms of how to roll out, how to issue work permits for citizens and sometimes permanent residents of those countries. And that's why we need to wait for all the details as we move forward. But at the end of the day, the main pillars of CPTPP is to elimination of tariffs on most goods and services, enhance protection and opportunities for investors, a stronger IP rights and enforcement, non-discriminatory access to government contracts, and comprehensive mechanisms for resolving disputes. And in terms of labor mobility, as I mentioned, it facilitates movement of business persons among member countries, which it expands because we do have a definition under the immigration law who a business person is. But with the mutual agreements that we have with those specific countries, we have expanded those definitions. It makes it a lot easier for people just to travel to Canada as business people and do their whatever they want to do as business people and then leave. Now, in terms of the work permit opportunities, we do have the ICT and investors options for CPTPP as well. They are very similar to the options that we have under the CUSMA agreement with Mexico and the United States. So I'm not sure if it will be that much different under the ICT regime for UK citizens. I mean, we already have an agreement in place, but what we do have, and it's a little bit different, is CPTPP professionals or technicians and CPTPP spouses. The interesting part is that the agreement that we have for spouses and common law partners between United Kingdom and Canada is only limited to ICT applicants. So if somebody secures a work permit under other agreements between the United Kingdom and Canada, and their spouse or common law partner wants to secure a work permit, we usually need to apply a more generic code called IMPC 41 to be able to secure a work permit for the spouses. It doesn't make things more complicated. It's just that we need to take a different route for them to secure the work permit. Under the CPTPP, it's automatically embedded in the system that if somebody secures a work permit, their common law partner or their spouse can also apply for a work permit. The government of Canada in 2023 generously extended the work permit options to children of people who secure work permits in Canada as well. And that means that for children, assuming that child is allowed to work in Canada, and depends on jurisdictions, sometimes children can start working as early as being 11 years old, but we can apply for work permits for children as well to allow them to work in Canada while they're studying or while they're accompanying their parents. And just to let you know, under the immigration law, a child or a dependent child is a child who is under 22 years old, and that child is not in a marriage or common law relationship situation. There are some exceptions to that rule that even children over 22 could qualify. But in terms of the CPTPP professionals or technicians, what we're looking at for professionals is that they must have a job offer from a company. So if you look at the UK situation, we'll see that we are usually looking at contractors, somebody who is being contracted to do something in Canada. But under CPTPP, we're looking at a regular employment relationship between the Canadian employer and the foreign national. Under professionals, the job must fall under tier 0 or 1 occupations. Just to give you an idea, tier 0 are management occupations in Canada, and tier 1 occupations are those occupations that usually require a university degree to do those jobs. And then they must also have a post-secondary degree of 4+ years of study and any additional educational requirements. Having said that, with the mutual agreements we have with individual countries under CPTPP, make exceptions to this. For example, in Australia, majority of bachelor's programs are only 3 years, and we have agreed to issue work permits to people that they have the 3-year work educational experience. And in terms of work experience, minimum 2 years of paid work experience in the sector of activity. And of course, in terms of the salary that they receive in Canada, that salary must be comparable to what Canadians receive. Now, the Canadian government has a website called Job Bank, which they post jobs. On top of posting jobs on Job Bank, one of the roles of a Job Bank is to find the salary range for each profession in each region in Canada. And when we look at those, we have a median salary. So we have the low end of the range, we have the high end of the range, but we also have the median range. And then if the salary of the person is less than median of the salaries in that specific region, then it is not acceptable. So they just want to ensure that the idea is not to replace Canadians with cheaper workforce from outside Canada. In terms of technicians, very similar. The difference is that now we are hiring somebody under tier 2 or 3 occupations. Usually for tier 2, 3 occupations, we're looking at somebody who has a college degree college diploma or certificate, and they also have done some on-job training, especially in terms of tier 3 occupations. Now, what I'm saying is just very broad. Obviously, based on the job offer that we receive, we need to look into the exact NOC code and see whether it falls under tier 2 or 3. And then in terms of the post-secondary or technical degree of 2 years is another requirement. Here we need minimum 4 years of paid work experience in the sector. And as I'm just like the professionals, the salary must be comparable to Canadians. Now, the initial length of a stay is similar to what we have with the United Kingdom, which is 1 year. So that part is similar. But the part that makes it interesting is that now we can actually request extensions of those work permits. So in other words, the person can remain in Canada for an unlimited period of time. And that's the big plus for a Canadian employer, because if they hire the person under CPTPP, they can just extend their work permit. And usually the second extension is a 2-year extension. So every 2 years, they just can extend the work permit of their employee, and they can remain in Canada for as long as the employer in Canada needs them. I think part of the rationale behind this is a regular employment relationship comparing to contractual relationship that exists for UK agreement. And as I mentioned, for each of the specific countries, or at least some of those countries, we do have special agreements. Probably the most generous ones are the ones that we have with Australia and Peru. But I'm pretty sure that when the United Kingdom is added to this list, then we will see some specific agreements with the United Kingdom as well. But for now, at least we can stick with that general agreement under CPTPP. And then, as I mentioned earlier, under CPTPP, the spouses or common law partners could also receive a work permit in Canada. Just to let you know, the common law partnership under the immigration law means that two people have conjugal relationship for a period of at least 1 year, which is different from some of the jurisdictions in Canada. For example, in Ontario, common law relationship means you have cohabited with each other for at least 3 years. But under the immigration law, it only requires 1 year of cohabitation. Now, I did a quick comparison between F66, X67, and T52 in terms of what are the differences. And I would say the big one would be the duration of work permit, which is initially 1 year, and the extensions are possible. However, for F66 and 67, you usually encounter the issue of that ban. So you can extend it, but you need to wait 12 months before you extend it. But the rest is just a quick comparison. In terms of the spouses, as I mentioned, by default, we don't have a work permit option for spouses under the UK agreement. However, we can apply for the spouses under C41. I have done this before for my clients, and it worked very well. But under CPTPP, they can apply just for a work permit directly based on the agreement. And that's pretty much it for my presentation. So if there are any questions, I'd be more than happy to answer. You can also get in touch with our business development manager, Ayaz. I have included his email and phone number, or our marketing and sales manager.
That's fantastic, Al. And there's I don't know if people noticed at the beginning. I don't know if you can see it on the screen. I have Al's book, 88 Tips on Immigration to Canada. And tip number 17 is 2.5 pages of acronyms. So if you were listening to that and thinking there's so many acronyms going on, I actually haven't started. 2.5 pages of them. and I think there's probably more every year. So do get Al's book. It's very useful, at least for explaining some of these things that are going on. I actually had a quick question myself, if I can jump in before the rest of the viewers. You mentioned that professionals or technicians need to be sort of regulated within the province they're going to work in for that to work. Ontario has over 100 regulated trades and professions, I think. So is there any trade or profession which isn't regulated in Ontario?
Actually, there are a couple. There are a couple, just a couple. As far as I remember, carpenters do not need to be regulated. Chefs do not need to be regulated. And also, to the best of my knowledge, welders do not need to have a license. And it's different from other provinces because most provinces require welders to have a license. Of course, these change constantly. That's a little bit outside my area of expertise, but because I have clients that they deal with these situations, I will every now and again get in touch with the authorities and review them. But yeah, you're correct. Most of the trades, they are regulated in Ontario, and receiving a license is such a tedious job because they require extensive experience. Normally, they ask the person whether they have 6 years or more of work experience. Sometimes they need to go through interviews, they need to present their documents, and at the same time, most of them, they need to do the Red Seal exam. And then if they pass all of those, they could receive a license. But as I mentioned earlier, there are circumstances in which when a contractor is coming to Canada, we can ask the regulatory body to issue a temporary license for that person to be able to do their job. So they just, they don't need to go through all these steps, at least for a few months.
Right, right. If other people have questions, I'll let them jump in. I always have more anytime we have these conversations. We always have more. But Dolores, do you want to ask a question?
I do. Hi, everyone. My apologies for joining you so late. I caught the tail end of your presentation, which was very, very informative. I'm wondering if there's an opportunity to receive the presentation. Are you able to share that with us or send it to us?
Of course, I have already shared that with Martin, and I don't know if I have your email, but if I have, yes, I will definitely take care of that.
Wonderful. Thank you. I appreciate that. And again, my apologies for joining you so late.
No worries.
Yeah, we have Dolores's contact details, so Dolores will send it on to you. And depending on how big this recording ends up being, I think we'll probably send a link rather than the recording itself, so then you can listen to it at your leisure as well.
So can I ask you if you are able to share that recording with us, is there an opportunity for us to share the recording with our members? Because I think there's some, again, I only saw part of the presentation, but I think there's some really great information in there. Is that something that you would be okay with, or?
And when you say members, Dolores, you're part of the Niagara Chambers of Commerce.
Yeah, South Niagara.
I'm absolutely okay with that. Yeah.
Wonderful, thank you.
I do notice one spelling mistake, I think, in the email for your marketing. It's marketing at PRSIA. So
yeah.
before people send that, do correct it to Parsai. That's
sure. I will take care of that.
I also noticed earlier in the presentation, it mentioned that part of the trade agreement was to promote mutual recognition of professional qualifications. And I have a bias here. I'm an accountant by training, and we're constantly fighting with the local accounting professions to get mutual recognition. Do you know, like, is there a body that's actually charged with doing that promotion of mutual recognition, or is it just an aspiration that's lost somewhere in the depths of this agreement?
I would say it's more of an aspiration. The problem in Canada is the authority that those regulatory bodies have, and especially the fact that a majority of them are provincial. It makes it so complicated. Even when I came to Canada, I remember that we had to submit an application to show that we are qualified as an engineer. And I was an engineer. And I actually received the approval that they recognized me as an engineer. But then later I realized that the federal body that recognized me, they had no authority in any of the provinces in Canada. So I had to go through the training again here and then and so many different steps that, you know, I called it quits. But generally speaking, I don't think the federal government will be successful in have a solid solution to this problem, at least based on the current structure.
Okay. And on the topic of engineers, I know a little while ago in Alberta, there was a company was being sued because they were advertising jobs for software engineers, but the word engineer was protected in Alberta.
Oh
And
my
they were being
goodness.
sued for that. They actually the Engineers Association lost that suit, and the government subsequently changed the law to clarify it. But that's particularly unhelpful when you're applying for this sort of temporary work permit. It can take so long to go through the courts that you give up, right?
Absolutely. And sometimes there are some nuances in the way that we can present things to the government. So sometimes we actually talk to the employer, talk to the employee, and we find a position that is not regulated in Canada instead of a position that is regulated, just to skip all the problems that we could face if it is considered a regulated job.
Right, right. And there are certain jobs. So within finance, you know, if you call someone an accountant, you risk coming under that regulation. But a financial analyst is not a regulated position.
Exactly.
It's the kind of thing we can do. Okay. Any other questions for Al from our guests? I would just say that from our conversations with the UK government representatives in Canada, my understanding is that whoever wins the UK election on July 4th, everyone is committed to some version of the CPTPP. So it's not like they're going to come in, change their minds, and withdraw from it. So I think it will perhaps there might be a little bit of a nuance in some of those details that Al mentioned in terms of specific agreements between countries. But it doesn't matter really what happens on July 4th. We will get something that looks like what we just talked about. Okay, any other questions for Al? Otherwise, we'll call it a day, and then we'll look at this recording, make sure it's good enough to share with people, and we'll send it out with the slides.
Nope, no questions from me.
Thanks, Mark.
Okay. Thank you
Oh.
very much, everyone, for attending. Yeah, you have a question?
I was just suddenly thinking we were talking about CPTPP.
Yeah.
It's like TCP in England. That keeps going through my head. When I came to Canada, I had to get my degree accredited because there was no kind of straightforward, they wouldn't accept it. And I had to go through the WES system and pay, plus I had to take an English test. Do you think that would change, that they would just recognize degrees that are from UK institutions?
So for the purpose of work permit, they are very flexible.
Mm-hmm.
But it is in the best interest of the applicant because the viewpoint of many officers has changed over the years that they actually require an ECA report or educational credential assessment report. It's not a bad idea to do that, but for most work permit applications, we don't ask our clients to do the evaluation, and we just submit the original documents and they accept it.
For the work permit, it worked okay, but it was when I went for PR, they needed
Absolutely.
it.
No, that's a must. For PR, it's a must.
Okay, yeah, because it was quite surprisingly, my 3-year UK degree became a 4-year in Canada. So
Yeah.
okay.
Yeah, the
Thanks.
equivalence is important for them. Yeah.
Yeah. Okay.
And for documentation, presumably it has to be in English or French.
That's correct. If it's not in English or French, they need to translate it into one of the languages.
Right. Okay.
Good.
If there's no other questions for Al, we'll call it a day. Thank you so much for this presentation, Al, and I do recommend once again the 88 tips on immigration to Canada. It's a very helpful book, although sometimes I read it and it completely blows my mind trying to work out which bucket we're in. And as you saw from the various different categories here, you do have to be very particular on exactly how you're describing every single part of a job or a contract. So do read that book, to have a look at this recording when we send it out, and do reach out to Al. As you've seen today, he's a very approachable person and very knowledgeable. So thank you all very much for your time. Thank you for joining us today.
Just one other comment from me, if
go
I
ahead,
may.
Mark. Yep.
It was just, talking about the LMIA. I actually came over on a French-speaking visa into Ontario because Ontario was wanting a lot more people who speak French. So I bypassed the kind of LMIA because it was a French-speaking visa. And I don't know how many of those you do, Al, but it was one of those interesting things.
Oh yeah, it's so easy to secure a work permit under IMPC 16 because we really need francophones outside Quebec.
Yeah. Okay. I just thought I'd mention it.
Yeah.
It's a good point. I also did my immigration in French, and it does get you. It is a bonus if you can do it, but obviously only if you can actually speak French. So they because they do check.
They do, they do check. And it only lasts 2 years. You get. I did it in the UK, and it only lasted 2 years. So then I had to do it again when I was in Canada. So
yeah. No, thanks, Mark. That's a very good point. Okay.
okay.
Go ahead, Mark.
No, that's fine. That's good.
Right. Okay. Thanks very much, everybody, and hope to see you all soon. I think Idalia is trying to organize an election watch party on July the 4th. Not so important for people watching the video, but we'll let people know if we find somewhere that's showing the BBC or something like that. We'll see how things go on July 4th and see what impact that has on the CPTPP. Okay, thank you very much, everybody.
Thank you very much.
Sure.
Bye.